Hey, I'm Nancy Cavey, National ERISA and Individual Disability Attorney. Welcome to this week's episode of Winning Isn't Easy. Before we get started, I've got to give you a legal disclaimer. This podcast is not legal advice. The Florida Bar Association says, I've got to say it, so I've said it. But nothing will ever prevent me from giving you an easy-to-understand overview of the disability insurance world, the games that disability carriers play, and what you need to know to get the disability benefits you deserve. So off we go. Now, in today's episode, I'm going to be exploring what an ERISA Section 510 claim might be, what a retaliation claim entails, and I'm going to give you these two specific insights about 510 claims. First is, can you bring an ERISA Section 510 retaliation claim against your employer if you are terminated because of the cost of medical treatment? And the second insight I want to bring to you is the issue of whether you can sue your employer if they interfered with your rights to claim disability benefits. Got it? We'll be back in a second.
Have you been robbed of your peace of mind from your disability insurance carrier? You owe it to yourself to get a copy of Robbed of Your Peace of Mind, which provides you with everything you need to know about the long-term disability claim process. Request your free copy of the book at kvlaw.com today.
Welcome back to Winning Isn't Easy. Can you bring an ERISA 510 retaliation claim against your employer if you were terminated because of the cost of medical treatment? Well, ERISA Section 510 makes it unlawful for any person to discharge, fine, suspend, expel, discipline, or discriminate against a plan participant or beneficiary for exercising any right that they're entitled to or may become entitled to under the employer's ERISA plan or policy. So that sets the framework. But what is ERISA? Well, the Employee Retirement Income Security Act of 1974 is a federal law. It governs employer-sponsored benefits like group health, life, disability, and even pension benefits. Now, what's important for you to understand also is that municipal employers like cities, counties, school districts, and states are exempt from ERISA, as are church plans. So we are, dealing with a finite number of employers. Now, the employer's plans or policies in that situation is governed by applicable state law. So if you've got an ERISA Section 510 claim, the question is, how can it protect you? Now, they can come as part of a general wrongful discharge claim, an age discrimination claim, or a whistleblower action where the employee also is alleging that the employer has attempted to interfere with the employee's protected rights or benefits. That's normally how we see these claims come. Now, Section 502 of the ERISA statute is the enforcement provision for ERISA 510 violations. You and your beneficiary can bring a claim to recover benefits that can be due under the terms of the employer's plan, enjoin any action that might violate the ERISA statute, or obtain other equitable relief. What's that relief? Well, that relief can include a reinstatement to your former position if you're fired. However, the relief doesn't include punitive damages, compensatory damages, or even monetary damages. Back pay may also be available in the form of restitution. The question becomes, well, who's got the burden of proof, you or your employer? The burden of proof and the order of production of evidence in a Section 510 action is governed by one of two court-created analysis or theories. The first possible analysis or theory is done under what's called the Price-Waterhouse mixed mode of analysis. Sounds like a legal term, doesn't it? This is used when you present direct evidence, such as conduct or statements by decision makers reflecting a discriminatory attitude that could have influenced the ultimate decision to terminate you. If you prove that, then the burden of proof is going to shift. And that's going to shift to your employer to prove by a preponderance of the evidence that it would have made the same decision to terminate you absent any alleged discrimination. Now, The second type, and the more commonly used analysis, is the McDonnell-Douglas analysis. That's known as the pretext analysis. Now, this is most used because many employers are just too smart to make comments or worse yet, to document the discrimination. So as a result, we are often having to present circumstantial evidence to establish the discrimination. The employer then has to present legitimate reasons for your discharge. If the employer presents a legitimate reason for your discharge, then the burden shifts back to you. This is a shifting burden analysis. Then you have to prove by a preponderance of the evidence that the true motive of your employer was to interfere with your ERISA benefits or your employment status. So how do you prove that causal connection, particularly in a health claim? Now, the key issue is going to be proving, as I said, that causal connection between the protected activity, i.e. the use of your benefits, and the adverse employment action that's taken by your employer against you. What's relevant in a health insurance claim? Well, unfortunately, it's often a matter of who said what or who did what. Sounds common, like a dispute between kids. Now, some of the most common relevant evidence is who made the decision to terminate you. Are they typically involved in a termination decision? Did they have access to the plan or policy? What was the knowledge that the decision maker had about your health and or that of a covered beneficiary, including any access they might have had to your healthcare expense information? What data did your employer have to evaluate the costs of the healthcare plan and the cost of this treatment, and whether they monitored that on a group basis or an individual basis? How closely and how often did your employer monitor the costs of the premium, the costs of each participant, and the beneficiary's healthcare costs to the employer? Does your employer do future healthcare cost projections for all employees or on an individual basis? And who gets that information? What is there in terms of internal correspondence, including emails, notes, or summaries of conversations that relate to your health, absenteeism, your health claim, and ultimately the decision to terminate you? And you're looking in that written material for information about the basis of the termination and any other evidence that might be relevant to a discrimination claim. Now, that correspondence can also be internal, and what we're looking for there is information regarding the healthcare cost projections based on what they're going to cost, your care is going to cost, monitoring of costs, and ways to reduce healthcare cost expenses. And of course, another issue is, was your termination the part of a reduction in force, and who else was terminated? That's quite a laundry list. But the question ultimately becomes, how does this laundry list really work in the real world? So we're going to take a quick break, and when I come back, I'm going to tell you the story of Thomas Karras and his employer, Southern Pine Trucking, so you see how all of this actually works in the real world. Got it? Let's take a quick break.